are live, and in this broadcast, we are a court case that is about standing and jurisdiction. And this is a Florida court case, and Florida is a judicial state. Okay. Um, that particular case that I have up there at the top, that's not the case that we're going to review. What we're going to review is down over here in the right hand corner, bottom right hand corner, no proof of trust. Okay, that's the one we're going to review for right now. And the reason we're going to review and discuss this particular court case is because people need to understand what validates a trust. We discussed earlier when we started this broadcast and it was interrupted. We started discussing the elements of a trust in reality. Okay? Now, what you'll find online is many instructions or how-to videos of how to set up a trust, the manifestation of the trust. Okay, you got to understand that when we write things down, that just means we're manifesting an idea or something that was um, spiritual in nature, or an assumption that we would like to have verified in writing, and that's what's called an express trust. Okay? It was in the air. It was how you felt at first. It was just an idea. And then you create a deed of trust, which means that this is what's done, the deeds that's done in your heart or in your mind, in your desires, and you manifested them in reality. Okay? Create a manifest for them to be carried on in reality. Okay? Your carrier would be your successors or beneficiaries. Okay? A person who would carry on your legacy. You would have to choose an individual for that purpose. But when it comes down to financial wealth, you would be passing that on to whoever your beneficiaries or successors of your family and company organizations that you are in your assets holdings when you pass on. So when you create a trust, you have to keep in mind two aspects: the living and the dead. Okay? The living and the dead. The reason I say the living and the dead is because all that are living will die. That is an surety. And that's what life insurance is for. To insure you while you're alive, not while you're dead. Benefits should be uh, accessed and used while you are alive to a life benefit policy. Please understand that. Your Medicaid and Medicare are life benefit policies. Okay? They benefit you while you are alive. I don't even think they hardly even give you any money to bury your loved ones through those programs, because they don't give a shit about you dying. They are there and designed to extract money from the systems while you are alive. Okay? And I said the systems because I don't want to go through all that explaining how that works again, over again, unless somebody asks and it's not clear. Let's get it.
May it please the court. Good morning, Your Honor.
Good morning.
My name is Dan McKillop with the McKillop Law Firm. I represent Shannon Rogers in this appeal.
Did you fill a notice of appearance?
I'm part of the...
Okay, now I want to stop right there because whenever the judge asks a question, that's an indication that possibly something has not been properly documented, and that's what he's indicating, that the lawyer did not present proper paperwork to be the representative of this party at this time, and it had not been transferred to his authority. Because anytime you take authority, it needs to be documented. As well, when you're in a case, if someone is taking authority over you, they have to document that. And what you're contesting in court many times is not the case. It's the documentation of the case is incorrect when people are talking about booking errors and so forth. Okay? We've got to understand the difference of when calling a booking error violation is appropriate. What court you need to be in when that is appropriate. A lot of people are just saying, don't say booking error. Okay? But they not understanding that the reason you're using that term is because you have found out some information concerning what a booking error is, but you are possibly applying it inappropriately or not being able to intelligibly and reasonably calculate the understanding where another person can clearly and concisely understand what booking error are you referring to. Okay? Many times the booking error is on the part of the prosecutors. Okay? So that it is a way of attacking and a strategy that many lawyers use, the ones that actually do their jobs, okay, and are competent representation. We discussed that in previous broadcasts of how lawyers can be incompetent, and this is the reason why you can, if you hire a lawyer and they did not win your case and you knew you should have won your case, then you can file with the court and say, I want my case reheard based on these facts. The fact that my lawyer could have argued standing and he did not. And that within itself shows that he did not provide for me a level of competent representation. And that shows his incompetence in acting on your behalf. And just like the courts can find you incompetent, you can find these persons that are in fiduciary capacity incompetent. And they have a rule or standard of conduct that they have to go by, policies, procedures, and protocol. The police are supposed to follow protocols. Okay, it's still procedures, policies, rules, and procedures. And that once they have not followed those policies, rules, and procedures, that is, by the court's definition, a booking error. Okay? Especially when you're dealing with the financial aspect of it, when it is not disclosed to you. You can also argue that in this alleged contract that you did not receive proper notices or proper disclosures in any contract. Those are two main very sharpened skill. I suggest you sharpen those skills of being able to identify when these type of errors have occurred on your opponent's side, because definitely they will be uh, poking holes in your defense or poking holes in your complaint in the same manner. Okay, because that's just standard court practice. Okay, protect the evidence. That's why you need affidavits. Affidavits overrule everything, especially when they state facts relevant to the case.
McKillop Law Firm. It's Jeremy Taylor is my associate who filed the
You
initial
didn't have your
brief.
name on the caption.
Your Honor, we do have one procedural matter. We did file a motion for sanctions based on a violation of supersedious. It wasn't noticed for today. I just want to make sure that the court is not expecting to hear issue on that today.
When did you file it?
That was filed after the notice for hearing went out today, but it's a significant issue. I think it would break into our time for...
Right. Well, we don't schedule motions for hearing. We do the motions in panels of 3. So if it's pertaining to this case, it would be resolved by this panel, but independent of the oral argument. If for some reason, hypothetically, an issue is uncovered that might require some sort of a hearing, you'll get some sort of extraordinary notice, but that's very unlikely. Otherwise, you'll get a ruling in due course.
Yes, Your Honor. I just wanted to make sure that the court wasn't
You don't want to,
expecting...
you're not waiving it.
No.
Yeah, okay, that's fine. So noted.
Thank you.
I'm going to start you 20 minutes now. You ready to roll?
Yes,
You want
ma'am.
some rebuttal time?
4 minutes, if I
All
may.
right, you got it.
So, we're brought here on an appeal from a final judgment of a mortgage foreclosure action. This was a non-jury trial. The plaintiff in the lower court is U.S. Bank National Association as a trustee for RASC 2005 KS5 Trust. I'm going to refer to them as the Securitized Trust. They were not the original plaintiff in this case. Originally, the plaintiff was U.S. Bank National Association as trustee, full stop. At some point in 2012, the plaintiff moved to amend their case caption to add in the RASC 2005 KS5 Trust, stating there was an error of the prior counsel to have not added that in. That is going to be relevant. We have 3 issues that we have raised on appeal. We break them down differently in the written briefs, but ultimately the 3 issues that we have are, 1, we allege that this standing that was proven by the Securitized Trust, which is based solely on the promissory note in this case, does not actually prove standing in favor of the Securitized Trust. That's going to be, I believe, the bulk of my argument, so I'll hit the other 2 and then come back to them later if I have time.
Now, you got their supplemental authority?
Yes, I did.
They quote a statute that establishes standing for a trustee?
Yes, Your Honor.
You want to address that now, or you want to save it for...
I'll save it.
Okay.
I will address it.
That's fine.
The second issue is the admission of the transaction history, which is not a transaction history. That was an inadmissible evidence because it was unreliable and not trustworthy. And third, I'll hit on this briefly, the admissibility of what we call a paragraph 22 letter. I believe the court's had enough mortgage foreclosures that when I say paragraph 22 letter, we understand what that means. The admissibility of that evidence we also claim was inadmissible because the plaintiff did not hit on all of the elements that they were required to in order to comply with the business record exception hearsay. So I'll circle back. Ultimately, the major issue here is standing. And there are some procedural issues that this will bring about. But the problem here is there were 4 documents that were introduced into evidence. The promissory note, the mortgage, the transaction history, which is not a transaction history, and the paragraph 22 letter.
Yes, I'm clear on that. I know it's called something other than transaction history. Is your position that it is a summary?
That's part of our position, but the reliability of that document is ultimately the biggest issue.
Okay.
Because as I will get to later, the document says not a transaction history, even though that's what it's being introduced as. It says not a transaction history for internal use only. Here, what I'm arguing about, though, is the promissory note. The promissory note was the only evidence that was presented to the trial court regarding the Securitized Trust standing in this case. Promissory note was not made out payable to the securitized trust. It was initially made out to Homecomings. Then there's two specific endorsements on the promissory note. One from Homecomings to residential funding. One from residential funding, and this is key, to U.S. Bank National Association as trustee, full stop. So the promissory note itself specifically endorsed U.S. Bank National Association as trustee, period. There's no identification of which trust that is supposed to be transferred to pursuant to the blank endorsement. Now this brings up two issues. I believe that they both require reversal. One of them is a de novo issue. It's an issue of law. We believe that, and we cited to the trial court during trial, 689.07 of the Florida statutes states that when there's a transfer of interest in real property, and that transfer of interest states there's a transfer to a trustee. If the transfer of interest does not identify the trust, then that transfer of interest is actually to the trustee, but in their individual capacity. Breaking that down, what that means is, pursuant to that statute, the endorsement was to U.S. Bank National Association in their individual capacity.
But the trustee still retains fiduciary duties to its beneficiaries, irrespective of how it's pled as between you and the trustee, correct?
That is true. U.S. Bank National Association, as your honors have seen, it has fiduciary responsibility to hundreds, if not thousands, of trusts, many of them on appeal here. That does not mean that there's a connection between this promissory note and this specific securitized trust. That's ultimately what needs to be alleged, nor was there...
I apologize for the low sound. There's nothing I can do about that. But what they're discussing in this exchange of communication is he's establishing that the at this point, when you appeal, you become the plaintiff and the other person becomes the defendant, okay? Because you have switched the table on its head, okay? You have switched the table on its head, which means that the person who was on top is now on the bottom. Basically. Not basically, exactly. This is how it works. Okay? The person who files an appeal is the person who is now the complainant. Alright? And they are their complaint should be geared towards an error made by the lower courts, okay? And what he is trying to establish is that the bank did not have standing, not that the court did not have standing, does not have standing to hear the case, because in any case, all three parties must have standing personal jurisdiction, okay? Personal jurisdiction is the parties must be held. The case must be held in the right jurisdiction, okay? And once you've established that who is the dominant person that the jurisdiction is governed by, you must determine who is the person or party that the dominating jurisdiction who holds the dominating jurisdiction, okay? And what I mean by that is that when people say you don't have jurisdiction, they don't understand that person do have jurisdiction. They just may not have dominating jurisdiction. Okay? Jurisdiction means they have the capacity to deal with the matter. Okay? If you allowed them to, they could judge on the matter. Okay? Or if the court rules and procedures did not make any specific ruling to say that they cannot hear the matter, then they are within their purview and within their jurisdiction to hear the matter. This is how people used to choose to have their court cases heard by Judge Mathis. He was not in their jurisdiction. He was allowed to hear the matter in his jurisdiction. Not in the person's jurisdiction, in his jurisdiction. Okay? And so what the person did was basically converted their personal jurisdiction and made it subject to Judge Mathis' open court jurisdiction. Okay? That's what type of court those are, open courts. And I'm not real sure about the word open because in learning these type of words and associating it with court practices, you do not want to be arrogant in your understanding or degrees of knowledge about a word, okay? Because a word can mean so many different things. It's amazing. And then it's scary all at the same time, because you're like, well, how can I ever know what they're talking about? A person is talking about if I never know what they mean by the words that they're using. Okay? Well, you could imagine someone who is learning the English language, what level of difficulty they may encounter coming across communications with people using different, using the same words but having different meanings. What level of confusion they could experience. Now, the good thing about people who are from other languages, their mind isn't zoned in to believing that a word has a specific meaning. And so it allows them to learn. And so in that capacity, we need to allow ourselves to learn. We need to become foreign to our own land and our own language, so that we can learn different understandings of a word and actually learn something. We can learn the law. We can learn an understanding of nature and natural law. And then you can go from there and understand all the other arms.
Any allegation, or was there any proof at trial of a relationship between U.S. Bank National Association? And ultimately, the issue of law, as we presented under 689.07, is regardless of whatever the fiduciary duty is between U.S. Bank and its hundreds of thousands of securitized trusts, it has no relationship to this promissory note as it stands. The four corners of this promissory note show a specific transfer of interest to U.S. Bank National Association individually. That creates what we believe is an issue of law. I've looked and shepherdized all of the cases that mention 689.07. I cannot see one where the court has interpreted as paragraph 2 or 3, and it's paragraphs 2 and or 3 which would apply to this case. So I do believe this is an issue of first impression for the court. The cases which we have seen and cited where the court deals with 689.07 paragraph 1, the court has said we're strictly construing this language basically what happens is if the transfer of interest says to the trustee, period, and does not identify in any way, shape, or form the
Well, let me
trust.
ask you a question. Let's say hypothetically a mistake is made in a transfer of this nature. What are you suggesting the parties do to correct that mistake if they don't uncover it until the middle of trial?
Well, we uncovered it well prior to the middle of trial. We filed a motion to dismiss their amended complaint for this specific reason. Issue.
But where was the prejudice?
Well, we're gonna stop the video and discuss is that what he's trying to make clear to the court is that the people didn't have the documents. This case been going on for a long time, and what the people I'm talking about is the bank. They're professionals. They shouldn't be given more time to act in dishonor. If they had a case and they knew they wanted to pursue a default on the loan on this mortgage, and they knew that, say for example, Chase Bank was the original loan provider where the person applied at, okay, but then they passed the buck off to the note. That's the buck. They passed the note off to U.S. Bank, and they assigned it properly and said you have the right to whatever obligations is due to me. It's like a quick claim deed, okay? They were supposed to have done a quick claim deed. It said, we sign over all of our rights, whatever assigns and interests and powers of whatever to you. And so in that kind of transfer, since they really don't have no interests or rights or assets in that, all they really signing over is a debt that they owe, okay? How would they then present any type of authorized or affirmed affidavits in the court to affirm an exchange that never occurred, okay? That could not have occurred. And so what they'll do is try to finagle around and present what is called supplemental documents, you know, a bunch of other documents that are circumstantial at best, and gather them all together. So 10 circumstantial documents equal one legitimate document. Okay? That's the only way I can explain that to you. That's how they get people on circumstantial evidence. They have a whole bunch of it. They don't have just one circumstantial piece of evidence that they're presenting. They have a whole bunch of circumstantial evidence that they're presenting. And that is what the judge is asking for. Did they present a preponderance of circumstantial evidence at least, okay, to indicate to that judge that he would be fair in ruling on it in their favor, okay, or for them to prevail. So what the judge here must determine is if in fact that substitutional information can in fact hold up in law to stand on the judgment of the lower courts. And really and truly, this is just an open and shut case. But like I said, there are a bunch of incompetent people juggling around their incompetent thoughts that is irrelevant to the basis of the facts of law concerning conveyance of property. It is very clear-cut, strict, open, and shut. Ain't no ifs, ands, and buts about it. And that's the way that lawyer is supposed to be presenting this case. Ain't no pussyfooting and asking all them other kind of ridiculous questions the judge is asking. But what he's doing is practicing law against the bench, which is wrong. And the lawyer not calling out on that. Because this is what they call moot court. You don't do objections and all of that kind of stuff in moot court appeal. Well, I did. I don't know why lawyers don't do it. Okay? Because I did object. And I objected equivocally. And I objected with grounds. And my grounds were sustained. So I don't know why these lawyers don't do any objections in their moot court processes. But that is a practice that is not to the benefit of their clients. I will say that. And it is evident because there are many objectionable statements that are being made on the record and asserted as truth. And that is not fair to the truth finder. The truth finder would be the judge who's hearing the case, or in cases where there's a jury, the jury is the truth finder. When you're not giving the truth finder facts which to measure and weigh out, then they're inevitably going to get a wrong measurement. They're going to rule improperly, but it's because they was giving it the proper information. Proper information is affidavits, affirmed facts, not statements, not business records that aren't certified business records. If it's a business record, why you can't get it certified? What's going on? Because if you certify it as a business record, and I then find out that it is not a business record, what is going to happen is now you've set yourself up for fraud on the court. So many times they won't set themselves up for a fraud on the court by submitting certified affidavit type documents in the record, and that is your way to stick them in the gut, so to speak. Okay? You can shank the shit out their ass with that. You just gotta know what they was required to submit to the record, and they did not. And if you point that out on the record, the judge is not supposed to ignore that. And then if he does, that is grounds for appeal. Automatic. Because that is how you state that the person has not provided standing on the record. Because that is how you provide standing on the record. The documents he's saying that U.S. National Trust didn't provide is the documents that is required by anyone who filed a complaint. A sworn affidavit, okay? The complaint itself is a sworn affidavit, okay? However, independent from that sworn complaint, the plaintiff is required and has the burden of proof to submit more documentation that is certified and or affirmed. So you got to submit more affidavits than just your complaint. And Otherwise, your complaint is just an allegation. It stays in allegation status. It's just an allegation. It's not a valid complaint. It hasn't moved over. It hasn't been perfected. You'll hear that word a lot when it comes to court procedures, mortgages and loans, maturity of loans. It hasn't been perfected yet. Another word they use is nesting. Nesting. Okay? When they holding shit. And some of these companies, they hold the note and they don't move it. They let it rest. Let it nest or whatever they call it. And the whole purpose of that is they keep it moving so you can never pinpoint a moving target. Okay? If you're trying to trace down what in the hell happened with this money, you never know because it done went every which way. And it does not have your name on it. It's been assigned and reassigned and signed and reassigned and signed and reassigned and signed and reassigned to somebody else. Okay? So, if you're facing that somebody else in court, through all of that signing and reassigning, signing and reassigning, your signature was not involved. Therefore, you do not have a contract with that party. And in that regard, this lawyer could have said off the rip that his client did not have standing. I don't know why he gonna wait on appeal to talk about some motherfucking standing. It's ridiculous. Standing supposed to come off the rip. You don't argue no case unless they got standing. Why are you arguing the case? Like Yusuf said, from Secured Party Creditors University, SPC University. He'll tell you about that. He's real good with court practice. And he got his field down packed. It's not a reciting of random shit. He knows which laws are applicable and he learned them by heart so that he can recite them without looking at a sheet of paper. He can recite them on point. And nobody, everybody doesn't have to be crafted to that degree. Okay? But for someone to try to label him as a sovereign that's incompetent, they would not be able to effectuate that because of his competence level in articulating himself. When he first started, he verbalized his anger. It got in the way a lot, and not knowing some things got in the way, of course. Because when we don't know, we're going in thinking we know, but you really do not know. What is proof? Just because they brought you a piece of paper, that don't mean, and it's got numbers on it, and it say, and they said, like he said, they presented a document and said that it was a business record, and even the judge repeated the lie. I mean, not intentionally, but was under the impression that a business record was filed. But as the lawyer pointed out, there was no such thing that existed that we can refer to as a calculatable submission, because the document itself said right at the bottom in big letters, this is not a business record. So how can you submit a business record that say it's not a business record, but call it a business record? Okay, something in the milk not clean here. And this should have been called out, and documents should have been filed contesting the submission or admission of this into the record, not after the fact trying to fight that it's already. So, in that regard, we want to understand that even lawyers are not proficient in practice. So, don't think of yourself representing yourself as anything less than what a lawyer can do. Because one thing that you have that the lawyer do not have, he may understand the law, but the lawyer does not practice law. Okay? The lawyer is practicing the common practices of his trade, which is trading documents. That's all they doing. In and submitting and trading, just trading documents. And it's based upon your life, and they don't care about that. That's not of concern to them. And you need to know that and stop thinking, oh, I just need enough money to hire a lawyer. That's the stupidest thing in the world. Because you are taking care of you is not in their best interests. It's more so in their best interest the way the system is set up for them to help each other. In other words, he just a buffer to make you think he's representing you. Look how he's dragging you through all these court cases when he could have won your case in a lower court withstanding. How is he helping you? He's not. And I can show you how this lawyer erred in many ways, and that's what the judge is pointing out when he's asking him questions. He's basically telling him that it's some areas that you didn't address that's relevant to this case that you should have gone into more detail to present your case before the court. Okay? Now, maybe it's intentional, maybe it's not. But in any case, people need to be aware that just because somebody is labeled as a lawyer or tell you how many cases they have had, you need to know how many they won. You don't need to know how many they've been involved in. You need to know how many they won. You need to know how they won. Look up their records. Look up their cases and see what they said in oral arguments. Just zone right in to what they said during oral arguments. If you don't see any type of record of what they said in the oral arguments in one or two, three cases, then that means they're not known for arguing no case. Okay? Perhaps they're a type of lawyer that like to get win the case on technicality, but you need to know their strategy and what they'll be implementing on your behalf to make sure that that's the best strategy for you going forward. If you already have lost your case because of their incompetence, you need to go back and search their records and find out who else cases they fucked off and could have won. And use that and take that before the bar and let them know that this person is out here operating in malpractice. File a malpractice suit on them. Because if they are screwing over your case and it was an easy win, an easy layup, and then you research and find out they did somebody else, ain't no telling how many more people they done. Who else life they messed over with their incompetent, um, but through collateral damage of their incompetence. Because yes, you not doing what you're supposed to do can cause harm. That's the reason why they have laws that govern neglect. You neglect to cut your yard, you can cause snakes and all kinds of infestation in your yard that will then spread out to other people's yard. Yes, when you don't do something, yes, you can cause a problem. And sometimes in these cases, people are causing a problem because they don't want to do something. They want to do all these other papers instead of filing one paper they could have filed to this one person. They want to file 10,000 documents to somebody else instead of to the person that they have an issue with. When the Bible said, go to your brother if you have a problem with him. And if he don't receive you, then you take it to the elders. And if that person acts in dishonor, you do not return the favor. Okay? You do not act in dishonor. Because that's called unclean hands. You can't say that their hands not clean and your hands not clean. They can call unclean hands. And the case is a wash. Okay? So be aware of all of these things, the counter or actions. These are what's called counter actions. Other things that you can trigger other liabilities by doing certain things. You trigger another liability by hiring a lawyer that may say things on your behalf. I was watching, and we have here, we'll let the ambulance go by. And we have here broadcast where we're critiquing a case about the bills of exchange. And the guy was in prison for using a bill of creating a bill of exchange, not for using a bill of exchange. And people will run off and say, oh, you can go to jail for using a bill of exchange. No, you can't. That man created a non-existent money order supposedly issued, but the way it looked, it was issued by the Department of U.S. Treasury, which does not issue money orders. And that's what made what he did. And he used their routing numbers, got all kinds of information that he should not have and put it on there. Personal information, people's names, the chief financial officer or something like that. Well, anyway, the point is that is what can be considered as a not a forgery because they didn't have money orders, okay? But they categorized it as a fictitious instrument, okay? Now, it's real because he created it, but it's not authorized by the names that he put on there. He didn't put that he was issuing it. They could not have put him in jail for that if he would have he was issuing it, okay, through his own personal private banking system. But he put that the U.S. Treasury was issuing. And that's where he went wrong. Because people need to get out of their minds somebody work for you. They do not work for you. They work for themselves. Let's be clear. Ain't nobody creating no corporations, whether they non-profit or not. Ain't nobody creating no corporation for you, to work for you. That's not even how the papers is worked up for no one individual purpose or person, okay? Most nonprofit entities, that especially ones that are private owned, are drafted in a way that they're contracting services to the public. Okay? They're a private entity, but they're contracting services. They're a corporate entity, but they providing services for the government, okay, of the state, the governing orders of the state, and that's their claim. All right? So it's not for you, it's for the governing orders of the state, which that's another corporation. So that's still not for you. Let's be clear. Whatever documents you draft are for you. Let's be clear. Whatever documents you draft in a bill of exchange, you draft them motherfuckers for you. Don't be putting other people's name on there unless they are the payee. Ain't nobody gonna have no problem with you putting their name on there as a payee. And that's where he went wrong. That was the fictitious aspect of it. The money was coming from his trust, but he said it was coming from somewhere else. On a check, it appeared on his face to be coming from somewhere else. And that was what unlawful. Matter of fact, however he designed it, I guarantee you he went renegade from the instructions that's on the bill of exchange. I haven't even read all the instructions, but I have read enough to know none of the ones I read instruct you to put nobody else's information on there, except when you put the U.S. Treasury, it tells you exactly how to include them. What to say. The exact words. So, why would you deviate from that when they gave you the exact words right there? I ain't trying to deviate. Even when I drafted the documents for the nonprofit federal status, where it said this is what the clause and the terminology we are expecting to see in your dissolution. Okay. I wrote in there word for copy paste, word for word. That's not plagiarism, because these are the words that are expected in that particular section and in that governance. Those particular words calculate to public benefit. Okay? You gotta understand the words gotta calculate up to something. They can't just be however you feel something is and believe things to be. They got to calculate up to something. And that's why his presentment calculated up to fraud of fictitious instrument, okay? An intent to defraud the public. And they also used the fact that he was teaching other people and had people paying him to draft up these documents, and they got in trouble concerning the same type of document, because they just found a loophole in his process And he had probably been processing some good documents. And they said, oh, we got a live one right here. And they waited until he processed the wrong type of document. And they got it. So, y'all need to just stop quickly processing documents. Stay in the safe zone. Learn how to process the bills that is sent to you in the mail. Any bill, any advertisement for a credit card, that is a bill. That is a offer for an exchange. They most likely have already accessed your credit. They have accessed your personal information somehow. They have your personal home address. And so they have violated your rights. And because they know that they have violated your rights, and you should know that they have violated your rights when they did that, you can use that fact as leverage when you contact them if they try to deny you. And say, none of these papers said that you wanted me to call you and you wanted to run my credit to deny me. Not on now one of these papers did you say you offered a denial. You didn't offer me a denial. You offered me an approval. It said approval, credit approval. I didn't even take out the time, spend the time in my day to call you for a denial. Who does that? That's an unreasonable offer. It never was an offer to begin with then. Well, we was going by your credit. Well, that wasn't what the offer said. That you would use an excuse later to deny me. It didn't say that either. That's false advertisement. And this will crack down on a lot of the fraudulent behaviors once people understand what is going on. When you're getting 30 gazillion thousand calls in a daytime from Medicare and Medicaid, it's because you got an open credit account. They trading and accessing every time they call you. They fraudulently accessing these accounts and getting power, using alleged power of authority by whatever type of business they are, that is in the right category that will allow them access to the information. They're purporting to be something that they're not. Because if you didn't even know that they were accessing your information, they're purporting to accessing your information on your behalf. How can they possibly be doing that? They have no proof that they have your power of attorney was given to them by you. And it can't be given to them by somebody else because it's your power of attorney. And a lot of times people insinuate that that can be done. And no, it cannot. That can only be done with a child. The mother, the parent, can give power of authority to their mother and or aunt, uncle, something, whatever. I've done that before with my child, with my sister, because my daughter was in New Jersey with my sister, and she needed to enroll her in school and so on and so forth, and take care of her. So I gave her limited power of attorney. And then I revoked it. And that's another thing you got to remember to, when you do limited power of attorney, Sometimes, even though the term itself limited, if the document doesn't say from this day to this day, who knows what the limited term was until you revoke it, okay? And make sure that it's written down that it's been revoked, because a person can continue to act upon it because it had no date on it, the limited, all right? The limit its power from this time to this time, from this date to this date, for one call or what, until they reach the person, and then, it's understood that they'll cease communication after that. Not keep calling them, asking them questions about you. See, that's presents a level of unlimited power of authority, even though the document itself says limited. You got to understand, the words don't mean shit if the actions don't line up. And this is why people put a lot of words in their contract to make sure they cover everything. But make sure you put them dates, perimeters, provisions. I can't speak on every contract and its performance terms, but performance terms needs to be very clear and concise. What your expectations of each other are. The reason that you can make a claim against a mortgage company that is foreclosing on your property is because that company has violated some terms of agreement. First and foremost, they did not disclose a lot of things. And you can, once you identify what those things are, okay, for example, they didn't disclose to you that the note was securitized and that they would be trading on the note and so forth, and that you have primary interest in the note, and that you were supposed to be receiving dividends on that note. And then that's when they tell you, we've been sending you dividends and you've been sending us money. And so since you was giving us donations, we kept them. And they're not going to ever say it like that. But that is what was happening when you was paying your mortgage note. Because they sent you a coupon with your bill if you received the bill in the mail. A lot of people who call themselves trying to get up to date with these new technologies is unwise with their finances. You need to, the reason why you didn't get no coupon, you wonder where your coupon is because you didn't get no mail. Gotta get it in the mail. Coupon come in the mail. When you receive all your bills in the mail, old school style like I do, send my shit in the mail. When they send it to you in the mail, now you have a coupon with that. You'll be able to see what I'm talking about. Look at the bottom of it. Sometimes it's at the top. The coupon is there. They gave it to you. Use it. Take the money they gave you. Yes, it's money. It's a coupon. Just like when you go in a store and you take a coupon and they take money off your purchase. What is that equivalent to? Money. It's the same thing. Whatever they wrote your bill out for, they're going to write that coupon out for the same amount so that you can easily, and it probably already has your name on it, and you can type the words accept, that you accept it, okay? You accept it for value, right? And then you write instructions on there, what to do with the money. Pay to bearer, 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 pay to bearer, okay? Now, and you sign it like a check on the back. That's the extent of my knowledge that I can relate to you at this time, and be responsible for. But on a later date, we'll go through and have a visual of the actual bill, and then we'll show you some of the processes that people use or the endorsements, different types of endorsements that you can use to notify the billing department what your intentions are. And because they are the billing department, and you would mail that back to the billing department. You wouldn't mail it to a CEO. He don't know shit about finance. He's an executive officer. Send it to the financial officer. Or send it to the accounts payable department. All right? And when you send it to that accounts payable department, I believe, then if they have one, then otherwise you send it to a general CFO, Chief Financial Officer. Okay? But in any rate, I do know that if you send it to the address and you look on your bill, and it always is in little tiny writing, so get you a magnifying glass and look over your contract. And I guarantee you, somewhere on your contract, somewhere in small little writing, it's gonna be that it's gonna say, if you would like to revoke your contract, or if you would like to rescind the contract, it's gonna say something like that, revoke or rescind, okay? It's gonna say something about revoking, rescinding, billing errors. That's where people got billing errors from. Because there's all kinds of stuff that is related to the same thing, they're just using different words. Okay? But look for where they have a different address than the one that's on the face of your bill. They gonna have it, because that's where they operate. That's okay. So look for that other address, because they in cahoots with somebody else. And when you have to sue somebody, it's gonna have the arbitration section in there sometimes. I tell you, that's the same department, that number. Wherever it is, whatever they calling it, it doesn't matter. Just look for another address. Get your paperwork. Don't try to read nothing else. Just look for another address. You don't have to read all that itsy-bitsy, teensy-weensy writing to find this, what I'm trying to tell you. You don't have to read it. All you have to do is look for the formatting of an address, and then zone in on that bitch, scam that motherfucker, and look for an address. Then home in on the area and the context in which it was given. and read that area first. Those are my practices of examining my bills now. Okay? And I learned that from Mansa, and he'll tell you, read your bill. Why don't you read your bill? You just complain, you run away from it, you do everything but read that bill. Read it. Read the contract. See what does it say. What have they been saying the whole time? Okay? When you call and pay attention when you call, when you ask about a payment, the words that they use. And you'll notice you was the one that was saying that you owed it them. They said they called about your account. They didn't say they called because you owed them money. They said they called about your account. They're contacting you about your account. See the difference of the words? You said your bill was past due. Okay? They said the account was past due. Because you have a whole different understanding of bills and accounts. And what they mean by the account is past due is meaning they was expecting, since you was acting like you owed it them, they was just, carrying on with your wishes and continuing to charge you. And they don't want you to divert from that because it's a donation to them. And so they even start acting crazy and acting like you really do owe them. Take you to court and everything. They catch amnesia. Because you got amnesia. And they use that against you. That it was your account in the beginning. Who gave them control or authorized them or gave them power of attorney over your account? Nobody. You didn't. Certainly you didn't. You didn't even know that they was acting in this manner because they had gotten it. So how did you give it to them? You certainly would not have intentionally given them power of attorney over your financial affairs. Look what they do with it. This man is in court poorly representing the person whose home, their domicile is being foreclosed on by a fraudulent entity with no proof they even exist. And I did a video, real talk video, a long time ago that says it's your fault that they do this kind of stuff. And the reason why it's your fault that they do this type of stuff is because it was once upon a time you was an advocate of this type of behavior going on so long as it was being done to other people. But when it comes to knocking at your door, now you not okay with it. That's why your vote don't count. Because the people who been understood that this level of incompetence and abuse of authority can be harmful, we made a way out for that. What I mean we made a way out for that is I've been providing information for people to know the truth for years. I didn't just start. That's a way out. And I have increased in knowledge so that I make sure that I'm providing the content for my viewers that is worthy of their uh, continued viewership. Let's move on.
Your client.
Well, the prejudice is that
I mean, there should have been a comma as trustee, da 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 da.
Well, number one, I don't.
There's not a duplicate foreclosure out there that's going to be a problem.
I don't think that we can make that assumption, nor would I.
But that would be an example of prejudice. That's why I issued that question. And then you've got a statute of limitations problem. But I mean, I'm just trying to think where you're coming from. If it's just an error in a nomenclature, is that enough to say they didn't carry their burden of proof, as opposed to the judge factored that in and said that really wasn't enough, that was a mistake that goes nowhere?
Well, the judge had no other testimony on which to rely on other than this promissory note as it stands. Again,
you got two problems, as I hear you. Number one, you have the technical correction of the caption. And then which probably the judge could do, but I think your more basic point is that without the identifying trust, I have inadequate proof of standing.
Yes, Your Honor.
So the result, if I hear you correctly, would be dismiss, start from the beginning.
I believe that
which probably would not affect the trustee's ability to foreclose on a property, but it could raise some statute of limitations problem for any sort of money damages.
Assuming that all of the contractual conditions preceding had been complied with and whatnot. Yes, I believe so. I do believe that the court in this case should have granted the involuntary dismissal. I don't know that based on the four corners of what we have here, it would have prevented a securitized trust coming back later and proving standing by some other means.
So what we do is tell me why your solution is not make work and tell the bank to go back to go.
Well, because if it is make work, it's work that they should have done in the first place, Your Honor. Second of all, we have no idea whether this trust even exists. There's no evidence that was presented to this court that shows, number one, that the trust exists, number two, that they're the proper party to be pursuing this action. Even today, the four documents are the note, mortgage, transaction history that's not a transaction history, and the paragraph 22 letter, none of which mention even U.S. Bank National Association other than the endorsement, and none of which mention the securitized trust. Ultimately, I believe that de novo review based on the 689.07 is appropriate, but even if we go to the standard that's harsher for Mr. Rogers, and we go on whether there was competent and substantial evidence, the plaintiff in that case still fails because they have not provided competent or substantial evidence to show that this securitized trust has any interest in the promissory note and mortgage. That's ultimately what they had to prove. There was no documentary evidence, and there was no testimony evidence from the one witness, and that one witness had been employed or had been working on the case for all of 3 weeks.
Let me just, use my simple man look at this. They had the note. Isn't that evidence of possession of the note? They had the note, and there's a typo of some degree, but they had the note.
Now, the judge is trying to insinuate that they had the note, and he said it like 3-4 times, if I'm not mistaken already. They had the note, they had the note, they had the note. Not at any time, this is an incompetence of the lawyer. I understand you don't want to interrupt the judge. But who is the they? Who is the they? Who is the they, and did the they match the note? Because if the they matched the note, then there wouldn't be any appeal status for standing, because that's the equivalent of standing. So the judge has to be asserting for the truth, offering an assertion for the truth of the matter. He's offering an assertion. that is not a fact. Okay? He's offering an assertion. He's asserting that they had the note, and he keeps doing that and keep doing that, and the lawyer did not refute it, and he's not gonna refute it. Watch this.
Say that's no evidence of standing? They had the note.
There was no.
How did they get the note is my question. Somebody gave it to them. It was assigned and they didn't fill out the name correctly.
What I hear Your Honor asking is possession of the note enough to get them to where they needed to go? My response is, number one, there's no testimony of who they was.
Say that?
There's no testimony when you said they have the note. That's an ethereal.
Who's the they? Yeah, well, that's another question, right?
Which was never proven, and therefore there's no competent substantial evidence that the they, which needs to be proven, the they that needed to be proven below, was the securitized trust. There's no competent substantial evidence to show that they had possession of the note at any point in time. These notes end up showing up in the court document. The they eventually needs to be proven. If a defendant doesn't object to that, so be it. In this case, Mr. Rogers did. It was an appropriate objection, and it was an appropriate motion for directive verdict, which really should have been involuntary dismissal. I'll now get back to the 673.1011 argument. If Your Honor has looked at that statute, 673.1101 cannot avail U.S. Bank and the securitized trust for two reasons. Number one, it says that the person to whom an instrument is initially payable is determined by the intent of the parties. The initially payable person in this case was Homecoming's Financial, not the trustee and not the securitized trust. So this statute does not apply to that endorsement. Let's assume that
I can't use the statute for subsequent endorsements of the note.
As long as the legislature said what it intended to say, it says the person to whom an instrument is initially payable. So as long as the legislature meant initially payable, then I would present to Your Honor, no, you cannot. But let's assume that you can, just for the sake of argument. The second part is important.
Go back. If you're reading it correctly, then tell me how a subsequent endorsement is done.
This issue only deals with when a name is partially left off. So I sign a check, or I make a check out to John Smith, and I meant John Smith Jr. Or I write a check to my own trust, and I say H. Daniel McKillop as trustee, but I don't leave the I don't put the trust on there. This is a remedial statute to deal with that scenario, and the legislature says that we're going to remediate, but only when the instrument is initially payable. Okay. The second issue is
There's no common law rule for a subsequent endorsement.
As far as this issue goes, I do not.
Okay.
But the second part is also fatal to Appley's argument, is determined by the intent of the person, whether or not authorized, who was the issuer of the instrument. So if they wanted to use this statute, and even if we allowed for some reason them to use this statute at the trial level, evidence of intent would have had to have been presented, which was not done. The one witness that showed up was a witness for Aquin. She didn't testify that she had ever worked for residential funding, and residential funding's ultimate intent when the signing of the endorsement is what would have been crucial if the plaintiff wanted to use this at trial. To wrap this argument up, I would say that I believe that we are entitled either on a de novo or on a competent substantial evidence. And what we're asking for is reversal with instructions to grant the involuntary dismissal. If the court, for one reason or another, on any of our arguments, allows for a retrial, I would politely ask the court address the 678.07 issue, because I believe it will come up at retrial. I don't believe that we need to get there, but because I believe there's other reasons. I believe that we can get more narrow if necessary.
You're getting close to your rebuttal. If you want to keep going or save it.
Yes, Your Honor. I'll hit briefly on the admissibility of a transaction history that's not a transaction history. The one piece of evidence that was presented as to damages was a document from Aquin Loan Servicing. The plaintiff hit on all the magic words for admissibility of a business record exception when they first introduced it. Mr. Rogers reserved voir dire and on cross-examination brought out and got the witness to admit that the document says on itself, not a transaction history for internal use only. The issue there is reliability of the evidence. A business record is admissible if you get all the magic words in, and as long as the document does not show an inherent unreliability. Here, the document is unreliable because it says it is not a transaction history for internal use only. The only way for the trial court to have admitted this is to have granted a paradox, where they said that we're going to find the reliability of this document other than the portion of the document that says it's not reliable as a transaction history. That paradox, I suggest to the court, should not have existed and made this document unreliable as evidence. For that reason alone, it was the only evidence of damages. I think that would have also entitled us to a directed verdict. My other arguments, if I don't get to them in rebuttal, I would leave for my brief.
Save you 4 minutes.
May it please the court, Marianne Couch for Appalachia U.S. Bank. I'd like to start with the issue of standing, since that appears to be the most important issue on appeal. In my notice of supplemental authority, I alerted opposing counsel in this court to Florida Statute 673.1101, subsection 3. Opposing counsel was referring to paragraph 1 when he stated that this statute only applies to it when an instrument is initially payable. That's incorrect, and that only applies to paragraph 1, which I'm not arguing applies to our situation. Under paragraph 3, a person to whom an instrument is payable may be identified in any way, including by name. It goes on to talk about the purpose for the purpose of determining who is a holder. It in no way references the initial when the note or negotiable instrument is initially payable. So that is not relevant to this court's consideration. Because the note was secondarily, thirdly payable to U.S. Bank as trustee, under paragraph 3, subsection B1, that is payable to U.S. Bank as trustee, regardless of whether or not any beneficiaries were named. Now, it's Ms. Rogers' position.
Doesn't it make a difference if, let us assume that U.S. Bank acts as a trustee for millions of different batches of investors for these notes, and when the assignment is made, there's no way of knowing if it's batch A or batch B of beneficiaries. So conceivably, you've got some other note floating around out there.
Well, respectfully, Your Honor, the note is clear as to what loan it's referring to. The complaint is clear as to what loan it's referring to. The fact that the U.S. Bank chose to foreclose in a more specific name doesn't affect its standing.
The endorsement is on the note.
Yes.
That Mr. Rogers signed?
Yes.
It's not in the lounge?
No, it is on the note.
On the note?
Yes, Your Honor. It's a second endorsement. There's a previous endorsement. So it's our position that under Florida Statute Section 673.1101, the argument regarding initially payable note is completely irrelevant. And this statute does directly apply to our specific situation. When you've got a negotiable instrument, a note that is specially endorsed to a party as trustee, then the person who is the holder of that note, of that negotiable instrument, under Florida law, is the trustee. And under Florida law, the holder is the one entitled to foreclose. Now, initially, U.S. Bank filed this foreclosure complaint back in 2008 as U.S. Bank as trustee. That complaint was actually dismissed a few years later, and without prejudice, and U.S. Bank was allowed to refile an amended complaint. It did so and named the more specific name, which it thought at the time was proper. But it's our position that U.S. Bank had authority to foreclose as U.S. Bank as trustee or U.S. Bank as trustee for the specific trust, RASC 2005 KS.
Does the record tell us when these endorsements and assignments are made, is the bank as trustee for a yet-to-be-formed RASC 1 or RSC 2? Does the record tell us?
The record does not tell us, Your Honor, and I'm not sure.
No chain of title?
From elsewhere, but
That's a no.
so it was endorsed to U.S. Bank as trustee under Florida Rule of Civil Procedure 1.2110, the real party and interest rule. U.S. Bank, it's our position that U.S. Bank was allowed to foreclose as trustee, which it initially did, or naming the specific beneficiaries. And this did not affect its standing to foreclose. And this goes to a bulk of appellants' arguments on appeal regarding the motion to amend case caption. Once U.S. Bank filed the amended complaint, Ms. Rogers immediately filed a motion to strike the amended complaint. In an abundance of caution, U.S. Bank then filed a motion to amend case caption. That was well within the trial court's discretion to grant that amendment. Amendments are freely given. It's a liberal standard. And so certainly the trial court did not abuse its discretion in granting the amendment to the case caption. Additionally, the issue of standing is at issue in regards to Ms. Rogers' motion to dismiss and motion for directed verdict. And it's our position that because standing was clear from the pleadings, from the testimony at trial, that there was no issue and the court properly granted, did not grant the motion to dismiss or the motion for directed verdict. Regarding, and one more issue on the statute that opposing counsel referred to, a requirement of an intent, that we were required to show that there was some intent regarding the trust at trial. That also is only in reference to paragraph 1, so I just want to ensure that the court's clear that the initially payable element and the intent is only relevant to paragraph 1, which is not the paragraph that U.S. Bank relies on for its authority in the standing argument under this statute. And it's our position that the separate statute is completely irrelevant. That the purpose of that statute, that's Florida Statute 689.07, is really to prevent fraud in the creation of secret trust. When a third party, another person, goes and looks up at a recorded deed and it sees an entity as trustee and doesn't name the beneficiaries, Florida law gives ownership to the trustee in its individual capacity, only so that it's preventing and protecting against fraud and third parties relying on that, looking at it. That's an entirely separate issue than an entity's standing to foreclose as holder of a negotiable instrument. So it's our position that this court need not even look to that statute, not decide anything in reference to it, and only rely on the evidence admitted at trial, the note, which is evidence of our standing to foreclose, and the Florida Real Party and Interest rule allowing us to foreclose either as U.S. Bank as trustee or U.S. Bank as trustee for the specific trust. Regarding the transaction history and the admissibility of it, it's important to note that the transaction history that was admitted into evidence includes roughly 19 pages. The first 9 of those pages detail the transaction history from about May 2007 till the time of trial. Now, if you look closely at the record, those first 9 pages look different from the remaining 10 that Ms. Rogers takes issue with. It's not clear from the record, and I'm not entirely sure if perhaps that was when Ocwen took over for GMAC and the records look a little different. But the first 9 pages detail the loan's transaction history from May 2007 till the time of trial, the operative time when Ms. Rogers went into default, and then all the time after there until trial, adding up those times for the transaction history and the amounts at issue.
Remind me where it says this is not a transaction history.
So those, yes, Your Honor.
The last 10?
The last 10 is where it says it is not that for internal use only, not a transaction history. Therefore, Ms. Rogers doesn't take issue with the first 9 pages, which are actually the relevant pages of the transaction history for this foreclosure
And
case.
that's not, those first 9 pages, that is not a summary, that is you would say it's an actual business record.
Yes, Your Honor. Our position is all of it is a business record, and actually Ms. Rogers never objected either at trial or in her briefs on appeal that any of the transaction history was a summary. So that's not an issue that was raised. And it's the remaining few pages that Ms. Rogers takes issue with that are a transaction history. First, they're not the dates at issue. And second, even though it says for internal use only, not a transaction history, U.S. Bank's corporate representative, Ocwen's representative at trial, testified that it still was, in essence, in substance, a transaction history. While that may go to the weight of her testimony, that there was a seemingly contradictory note on some of the pages of the transaction history, she's the person familiar with these records, and she said it was a transaction history. If anything, this is merely goes to the weight of her testimony, but it's important to realize that the remaining, the pages that are really at issue that in reference to this foreclosure case and the amounts due, Ms. Rogers takes no issue with, does not dispute that those are trustworthy, does not attempt to argue that those are untrustworthy, because none of those pages have that notation on them.
Do the last 10 pages show the same dates and dollar amount?
It's earlier dates. It's from the conception of the loan until about May 2007, if I'm remembering correctly, Your Honor. And then the other 9 pages are from May 2007 till the time of trial.
That's going to give me a cumulative amount anyway.
Yes, Your Honor. So it's our position that the transaction history was without a doubt properly admitted into evidence, and it was certainly not an abuse of discretion for the court to allow all of the transaction history into evidence, even though there was a slight notation on a couple of the pages not really at issue that it was not a transaction history. In regard to the corporate representative's testimony, in essence and all, at trial, Ms. Rogers, in the briefs, takes issue with the fact that she was an employee of Ocwen Loan Servicing who was servicing Ms. Rogers' loan at the time of trial. It's true that previously GMAC serviced the same loan, but Florida law does not require the servicer to come to trial or the lender to come to trial and to bring the actual records custodian who created the files, or to bring the individual, or to name the individual who created the files. In this case, we had Alicia Prather. She was an experienced records custodian at Ocwen. She was able to testify regarding Ocwen's records keeping systems, and she explained to the court on cross that Ocwen purchased GMAC, in essence, purchased all of its business records and kept all of GMAC's business records in its own system. Therefore, the default letter, the transaction history, and any other business records related to Ms. Rogers' loan were initially GMAC's records, but when Ocwen bought GMAC, they became Ocwen's records. So it was entirely appropriate to bring...
If there was a problem in the initial transaction history under GMAC, it would go to weight, not admissibility as a business record.
Yes, Your Honor.
It might not be reliable, but that's a separate issue than admissibility.
Yes, Your Honor. Yes, Your Honor. And it's our position that her entire testimony, not just the admissibility of those two items, the default letter and the transaction history, but that her entire testimony was properly allowed, and she was allowed to testify as to the business records because she was an employee of the current servicer, and Florida law allows such testimony, even regarding...
Does she have a similar position with GMAC? Did she come over with the documents?
Your Honor, it's not clear. It's not clear from the record. She started to say something at trial that insinuated that perhaps she had previously worked for GMAC, but it's not clear from the transcript whether she actually did. But she does testify that all of GMAC's records are in Ocwen's computer system. So it was clearly permissible for the court to admit her testimony as a records custodian, admit the default letter and the transaction history. And if I may, Your Honors, one last note that Ms. Rogers did not note in her argument to this court today, but in the briefing, is regarding the motion to strike the court's order setting trial. Ms. Rogers takes issue with the fact that the court set the case for trial before it was at issue. However, all the cases cited in my brief.
You set up for trial before it's at issue, but you just can't actually have the trial before it's at issue.
Exactly, Your Honor, and that's our position, that there was no prejudice here, that it was set for trial well in advance. They had notice, and it wasn't actually tried before it was at issue.
Okay.
Thank you.
Thank you. And I've saved you the 4 minutes you asked for.
Thank you. As to the issue of standing, plaintiff in the lower court can't and did not argue it both ways. And I don't believe that it would be appropriate for them to do so today. They did not try and argue and say either U.S. Bank National Association individually or the securitized trust has standing to foreclose. And I believe that it would have been inappropriate if they had tried to. They would have been showing up to the court wearing 2 hats in the same exact position.
Well, what's your response to their argument on paragraph 3 of the statute? You provided as they provided as supplemental authority.
I believe that 1, 2, and 3 are all applicable, but if we look at paragraph...
Your opening salvo was paragraph 1. They came back with paragraph 2.
Yes.
I mean paragraph 3.
Yes, I believe they're all 3 are applicable. They should be all read together. It's not an or. These are, the way that it's read is these are all rules, at least the way that I read it, these are all rules that apply to the payment of a negotiable instrument. But specifically 3B, 3B1, the instrument is payable to a trust, an estate, or a person, then it's payable to the trustee as the representative. They don't say, it doesn't go the direction that the plaintiff wants it to go. This section does not go that if it's payable to the trustee, we've really meant it's payable to the nondescript and non-mentioned trust. Additionally, there was no evidence presented at trial that this securitized trust, number 1, exists. Number 2, is the actual owner herein.
So isn't that taken care of if I've got an endorsement right on the note?
No, the securitized trust is not taken care of, Your Honor. The securitized trust is an alphabet soup.
But it certainly minimizes any risk that your client's going to get popped for a second note that's floating out there.
I don't believe that it necessarily does, because these securitized trusts, they come and go. There's no evidence, number 1, that it even exists, so there's no reason to believe that res judicata applies. Number 2, anyone, because the legislature and the courts have opened this up so much, anyone can come in and claim that U.S. Bank was a thief on the promissory note and enforce it again under 673.3091 under the lost, destroyed, or stolen instrument, and they would have a legitimate claim. If we're going to set up and allow these defendants or these plaintiffs to come in the manner in which they're doing so, at the very least, competent, substantial evidence of this trust owning this note and mortgage must be provided. And that wasn't mentioned. In fact, RASC 2005 KS Trust, I don't believe it appears on the transcript, at least it doesn't come out of the mouth of the witness in this case. Ultimately, that's the issue. And the interplay between 673 and 678, I would leave that up to the court. I believe it's first impression. I don't believe that 678.07 has been interpreted by the court in this manner. And whether the negotiable instrument or the transfer of interest in the property statute applies, I don't have any case law other than the best argument that I can make as to that. As to the issue of the statements about the transaction history that's not a transaction history, the court made no representation on what it was basing its final judgment on. We would have to actually go in and look at the first 9 pages and the last 10 pages and break them apart, which is not what the plaintiff in the lower court presented to the court, not what the trial court said they did. And what I find very often when I end up doing that is that some of the payments that are made appear on one ledger, not on the other. And there's no reason for us to make that calculation because they were presented as one document to the trial court. The document itself, 50% of it says this is not a transaction history. It's not reliable. And as to the weight of the evidence, reliability is a precursor determination for the court, I believe. It's not to be determined after, but it is part and parcel of the business record exception. And I believe the business record exception was not met with that paragraph 22 letter either, because the witness needed to testify specifically that she had knowledge of GMAC's record keeping at the time that GMAC allegedly created that letter.
You're coming down to the end of your time. If you want to wrap up.
I do believe that Mr. Rogers, and if I can make that correction, Mr. Shannon Rogers, is entitled to reversal with a directed verdict or an involuntary dismissal. Again, if the court sees fit to grant a new trial, I would ask for a written opinion on the 678.07 issue.
All right, thank you. Well argued. All right, we're going to go to the...
All right, our next case is Miltiades versus Thornburg Mortgage. Is that right? Creedon versus Thornburg Mortgage.
I know. It's like they're all bad.
Take your time.
Morning, Your Honors. May it please the court. My name is Jessie Carroll. I'm with the law firm of Creed & Gowdy in Jacksonville, and I'm here on behalf of the appellants. I'd like to reserve 5 minutes of my time for rebuttal. Fundamentally, before a bank is allowed to foreclose on someone's property, to take their home, they have to meet a basic minimum threshold. And that threshold is showing they have the right to foreclose, that they have standing. This court said in Stone versus Bank United that a party seeking foreclosure must present evidence that it owns and holds the note and mortgage. And here, the appellee, U.S. Bank, failed to prove that it owned and held the note or it had standing to foreclose. At trial, U.S. Bank claimed to have standing because it was enforcing a note endorsed in blank. But that note was placed into the court file by Thornburg years before U.S. Bank ever purported to come into to be the successor in interest. Now, a note endorsed in blank is negotiated through possession. Had U.S. Bank come into court possessing that note endorsed in blank, that would have been sufficient. But they never possessed it. And so this is a very different case than the Clay County Land Trust that they cited as supplemental authority, because in that case, the bank did come in and possess a note endorsed in blank, and that is enough. But where you don't possess it, you can't have the negotiation. You looked like you were going to ask a question.
And just as
That's the end of that. If you don't have the note, get your ass out of court. That's my thing. I'll wrap that and sum that up. Y'all can watch that on your own time. It is included in one of our Eagle Legacy court playlists. And so we appreciate you